Okay, welcome back to Law Nerds. This is going to be a series of videos on trespass to the person as a tort. So the videos are going to be broken down into assault, battery, defenses to assault and battery, false imprisonment, and then the defenses to false imprisonment. So this is part one. In this video, we're going to just go through really briefly the introduction, the definition of assault, the test for assault, and whether words can amount to an assault. In the next video, we're going to do the same thing for battery. Okay, so before we get any further, I just want to thank you for choosing us again, and I just want to let you know, don't forget to subscribe, like, and share our videos. Drop comments down below. Let us know what type of videos you would like to see in the future. Ask us any questions, anything that you need clarity on. We will try our best to respond to all your comments. Also, just to let you know that we have ebooks for all of our videos that will cover notes. So right now we have an ebook available for tort notes, and it would include trespass to the person. Okay, so trespass to the person comprises of 3 torts, namely assault, battery, and false imprisonment. It should be noted that trespass might only apply if the act is intentional and direct. The concept of a negligent trespass or an unintentional trespass is therefore no different from an action in negligence. It should be noted that these torts, meaning assault, battery, and false imprisonment, do not require proof of damage to be actionable. That is, they are actionable per se, and are used to protect the right to personal integrity and dignity. For example, the right not to be shoved, not to be wrongfully arrested, or not to be emotionally unsettled by those bearing ill will. In the Commonwealth Caribbean, civil actions for assault and battery are comparatively rare, except in actions for false imprisonment. Presumably because litigants prefer to seek redress in the criminal rather than civil courts. On the other hand, actions for false imprisonment are common, and a considerable body of case law has been accumulated around this tort. The definitions of these torts are found in the case of Collins versus Wilcock, where Lord Justice Goff defined an assault as an act which causes another person to apprehend the infliction of immediate unlawful force on his person, while a battery is the actual infliction of unlawful force on another person. So the assault is making the person apprehend the infliction of immediate force, while the battery is the actual infliction of the unlawful force. We can treat these two separately, which is what we're going to do, although in popular usage, assault and battery is used together. In the case of Fagan versus Metropolitan Police Commissioner, Justice James stated that assault is generally synonymous with battery. Therefore, to slap the plaintiff on the face is a battery, but to approach him menacingly with a clenched fist is assault. To throw an object at him is an assault so long as the object is still in the air, but if the object strikes him, there is a battery. Very often, the threat of violence will be immediately followed by the actual application of violence to the plaintiff's person, so that the defendant will have committed both an assault and a battery. An assault is a direct threat made by the defendant to the plaintiff, the effect of which is to put the plaintiff in reasonable fear or apprehension of immediate physical contact with this person. Therefore, the plaintiff must have been placed in reasonable apprehension of an immediate battery. The test The test as to what is reasonable in this context is an objective one. The plaintiff must establish that a reasonable man would have apprehended the infliction of a battery. It is irrelevant whether or not the plaintiff himself was afraid or scared. In other words, if a person of ordinary courage would not have been afraid, the fact that the particular plaintiff was afraid will not make the defendant liable. Conversely, the fact that the plaintiff was exceptionally brave and was not afraid will not prevent him from succeeding in his claim if a person of ordinary courage would have been afraid. It is important that the fear is of an immediate battery. The tort does not exist if the battery is likely to occur only at some time in the future. Once there is the apprehension of an immediate battery, it is irrelevant that the battery in fact never occurs. Let me repeat that. Once there is the apprehension of an immediate battery, it is irrelevant that the battery never in fact occurs. However, if there is no means, that is, the plaintiff has no reasonable belief that the defendant can effect his purpose of carrying the threatening behavior into effect, for example, shaking a fist while in a passing vehicle, then there is no assault. And this was seen in the case of Thomas versus National Union of Mine Workers. A great deal of discussion has been concerned with the issue of whether words unaccompanied by an action can amount to an assault. There are cases to support either view, but it would seem that the issue could easily be resolved by a reference to first principles. In other words, would a person reasonably apprehend the infliction of a battery in the circumstances? Clearly, some relevant considerations would be whether the plaintiff could see the speaker of the words, the nature of the words used, the identity of the speaker, any accompanying gestures, the tone of the words, etc. Is there, for example, an assault if one hears the words, your money or your life, spoken by a stranger in a dark alley? In the case of Ireland, Burstow and Ireland, this is a case in which a silent telephone caller was convicted of assault, and Lord Stein said, the proposition that a gesture may amount to an assault but the words can never suffice is unrealistic and indefensible. A thing said is also a thing done. There is no reason why what something said should be incapable of causing an apprehension of unlawful physical violence. For example, a man accosting a woman in a dark alley saying, come with me or I'll stab you. I would therefore reject the proposition that an assault can never be committed by words. In Tuberville versus Savage, T put his hand upon his sword and said, if it were not a size time, I would not take such language from you. It was, in fact, a size time. It was held that this was not an assault since there was no intention on the part of T to do so. The above situation must be distinguished, however, from a conditional threat, which can amount to an assault. For example, if the defendant approaches the plaintiff with the words, if you don't give me your money, I'll break your neck, there would clearly be an assault because the situation would cause reasonable apprehension of immediate violence. Okay, so that is it for assault. Next, we're going to cover battery. So stay tuned for that. Here's how we can be contacted. And the website itself is where you'll be able to find our tort law course and our tort law notes.